I'm Craig Smith, the director of the Center for First Amendment Studies. I have been the only director it's had for the last 25 years when we brought it to the campus in 1988. I'll be joined today by Dr. Kevin Johnson, who is the research director for the center. What we're going to be talking about today is the constitutionality of same-sex marriage. We are not here to persuade you one way or the other on this issue. What we are here to do is to enlighten you about what the Supreme Court has said on this particular issue and give you some background so that you can reach an educated opinion on your own. On September 17th, 1787, 42 of 52 delegates signed the Constitution, and it was sent out to the states for ratification. That's what we're celebrating today as summer winds down. In the time allotted, I hope to establish a context for the current debate over the constitutionality of same-sex marriage. Since the main roadblock to same-sex marriage has been state laws, I begin with a review of the erosion of states' rights over time, which has allowed for certain courts to rule that same-sex marriage is a natural right that trumps the state's prerogatives. Second, I will briefly examine the rulings that have led up to the current state of affairs. These include the landmark rulings in Loving versus Virginia, Bowers versus Hardwick, Romer versus Evans, and Lawrence v. Texas. While the founders met to revise the Articles of Confederation in the sweltering Philadelphia heat of the summer of 1787, they took the first step in eroding the power of the states. They needed to rein in the states because they had been given too much power under the Articles of Confederation, which had become dysfunctional. The federal government did not have enough power to enforce tax collection, to put down rebellions in the states, to arbitrate disputes over water rights among the states, and to strengthen the armed forces. The situation was so bad that the founders who met in Philadelphia decided to junk the Articles of Confederation and start fresh with the new Constitution. What emerged was a compromise that protected states' rights against the federal government intruding into their internal affairs unless such an intrusion was clearly among the enumerated powers of the Constitution. 3 years after its ratification, the Constitution was amended with a Bill of Rights in December of 1791, and the first 10 amendments to the Constitution that sought to protect the states and their citizens from the federal government by guaranteeing freedom of speech and religion, the right to assemble, the right to bear arms to form a militia, the right to privacy, a fair trial, and so forth. These changes to the Constitution went through the lengthy ratification process during which the founders confirmed that if you didn't like the way the Constitution was operating, you needed to amend it. James Madison, the major author of the Bill of Rights, wrote that the Constitution must be interpreted according to, quote, its true meaning as understood by the nation at the time of its ratification, unquote. 14 years after his presidency, Thomas Jefferson wrote that we ought to return, quote, to the time when the Constitution was adopted, recollect the spirit manifest in the debates, and instead of trying what meaning may be squeezed out of the text or invented against it, conform to the probable one in which it was passed, unquote. Earlier, Madison and Jefferson had written the Virginia and Kentucky resolves, arguing that the states had the right to reject federal laws that they believed were unconstitutional. In this case, the Alien and Sedition Act of 1798. Thus, even after the new Constitution took effect, the states retained an enormous amount of power as Jefferson became president in 1801. But with the debate over the Missouri Compromise in 1820, Madison heard alarm bells in the night over the question of abolishing slavery in the states. Matters came to a head again in 1830 when, in concluding his debate with Senator Hayne, Senator Daniel Webster attacked states' rights with these words, "Let us not become a nation bearing for its motto the miserable interrogatory, 'What is all this worth?' nor those other words of delusion and folly, liberty first and union afterwards, but everywhere, spread all over in characters of living light, blazing on all of its ample folds as they float over the sea and the land, and in every wind under the whole of the heavens, that other sentiment dear to every American heart, liberty and union, now and forever, one and inseparable." 20 years later, Webster presided over the Compromise of 1850, which again averted a civil war. Texas, which had been admitted to the Union as a slave state, had its borders fixed and its debt paid off. California was admitted to the Union as a free state. The Fugitive Slave Act was put in place to return escaped slaves, and to balance that, the slave trade was forbidden in Washington, D.C. In 1857, the Supreme Court upheld the fugitive slave law in the infamous Dred Scott decision. A year later, when accepting the nomination for U.S. Senator, Abraham Lincoln condemned that decision by paraphrasing Jesus. Lincoln said, "A house divided against itself could not stand, and that a nation could not endure half slave and half free." Lincoln was not selected as a senator that year, but 2 years later, he was elected President of the United States. 7 slave states, remembering his earlier words, seceded from the Union before Lincoln was sworn in as president. A month later, the Civil War began, and Lincoln argued that the states did not have a right to secede. The North's victory in the war, almost 150 years ago, changed the United States from a plural noun to a singular one. It strengthened the Union at the expense of the states. The single most effective blow to states' rights was the passage of the 14th Amendment, which guaranteed equal protection under the law and due process of the law for all of its citizens. Basically, this amendment allowed the Supreme Court over time to incorporate the Bill of Rights into the 14th Amendment's due process and equal protection clauses, thereby subjugating the states to the same rules that the federal government had to follow. This move was generated in no small part by Lincoln's claim at Gettysburg in 1863 that the inalienable rights contained in the Declaration of Independence superseded the Constitution. Thus, over the years, slowly but surely, states were forced to guarantee freedom of expression and religion to their citizens and all the other natural rights that were contained in the Bill of Rights. The most dramatic progress in this regard came during the tenure of Chief Justice Earl Warren, the former governor of California. Warren cobbled together a unanimous decision in Brown versus the Board of Education in 1954, which overturned states' rights to maintain separate but equal facilities for different races. In Mapp versus Ohio, the Warren Court applied the federal rules of procedure in criminal investigations to the states. In Pointer versus Texas, states were forced to allow all witnesses to be cross-examined. In Gideon versus Wainwright, the states were required to provide counsel to the poor. In Miranda versus Arizona, state and police were required to read arrest rights to anyone they arrested. This major erosion of states' rights, with an emphasis on securing natural rights through the 14th Amendment, set the stage for dramatic rulings regarding the states' rights to define what constitutes a legitimate marriage. However, the first step came in 1879 when the Supreme Court ruled in Reynolds versus the United States that polygamy was not in the best interest of children and outlawed the practice which had been common among Mormons and a few other religions. Perhaps even more dramatic was the ruling in Loving versus Virginia in 1967. Virginians Mildred Jeter, an African American, and Richard Loving, a white man, crossed the state line into Washington, D.C., where they were married. When they returned to Virginia, they were sentenced to 1 year in jail for violating Virginia's law against interracial marriage, known as miscegenation. The law not only prohibited such marriage ceremonies in the state, like every other southern state, it prohibited couples from going to other states, getting married, and returning to Virginia. In handing down his ruling, the trial judge said, quote, "Almighty God created the races, white, black, yellow, Malay, and red, and he placed them on separate continents. And for the interference with his arrangements, there would be no cause for such marriages. The fact that he separated the races shows that he did not intend for the races to mix," unquote. After their trial, the Lovings appealed to Attorney General Robert Kennedy, who referred the couple to the ACLU, the American Civil Liberties Union, which then appealed the ruling to the Supreme Court in the last year of Justice Earl Warren's tenure. Unanimously, the court ruled in favor of the Lovings and overturned a Supreme Court ruling of 1883 that had upheld a similar law in Alabama. Chief Justice Warren wrote the unanimous decision in which he said, quote, "Marriage is one of the basic civil rights of man, fundamental to our very existence and survival. To deny this fundamental freedom on so unsupportable a basis as racial classifications embodied in these statutes, classifications so directly subversive of the principle of equality at the heart of the 14th Amendment, is surely to deprive all states' citizens of liberty without due process of the law. The 14th Amendment requires that the freedom of choice to marry not be restricted by invidious racial discrimination. Under our Constitution, the freedom to marry or not marry a person of another race resides with the individual and cannot be infringed upon by the states." End of quote. While all state laws against interracial marriage were repealed, the states, particularly in the South, continued to uphold laws that discriminated against classes of people in other ways. The most notorious of these laws was the prohibition on same-sex marriage, which some states labeled sodomy or unnatural or deviant behavior. The statute of the state of Georgia was challenged in 1982 when Michael Hardwick ran afoul of the law by drinking in public. When he paid his fine, the court found that the warrant had contained the wrong date. A police officer was sent to Hardwick's home with the corrected warrant. He discovered Hardwick engaged in oral sex with another man and arrested Hardwick under the Georgia law prohibiting such activity. Hardwick sued the Georgia Attorney General Bowers to clear his name, and the ACLU took up his case. In 1986, in Bowers versus Hardwick, the Supreme Court ruled by a narrow 5-4 majority that homosexual sex was not a natural right, and therefore the states could prohibit it. The majority argued that Georgia had a right to codify what the majority of its citizens believed was an immoral act. The dissenters argued that sex between consenting adults was a natural right, and so privacy, in this case, was more important than what the majority had ruled on. It would be years before the argument of the dissenters was accepted. The first move to correct Hardwick came out of Colorado. In 1994, the voters of Colorado passed a ballot proposition that amended the Colorado Constitution so that it deprived lesbians, gays, and bisexuals of anti-discrimination law protection. They were no longer to be considered among the classes of people who had endured discrimination by the state. In 1996, in Romer versus Evans, a 6-3 ruling, the Supreme Court overturned the Colorado constitutional amendment, arguing the new law deprived a minority of due process and equal protection under the law. Writing for the majority, Justice Anthony Kennedy, a practicing Catholic, argued that it is not a state interest to discourage homosexuality, and there is no rational basis to do so. In his dissent, Justice Antonin Scalia, also a practicing Catholic, relied on the precedent of in Hardwick. He wrote, "If it is rational to criminalize the conduct, surely it is rational to deny special favor and protection to those with self-avowed tendencies or a desire to engage in that conduct." The stage was set for the repeal of Hardwick. It would come in Lawrence v. Texas, an emancipation proclamation for the LGBT citizens. Texas, which had outlawed sodomy, argued that it had the right to make laws that reflected the majority opinion of its citizens. The fact is that in 1960, every state in the nation had some form of anti-sodomy law. In 1970, a man was denied a driver's license in Connecticut because he was an admitted homosexual. It should be noted, however, that the Texas law was rarely enforced. By the time of the case, only 4 states had statutes singling out homosexual sodomy for criminal punishment. However, the Texas law remained on the books, and a conviction would require those convicted to register as a sex offender. In 1998, John Lawrence, a white 55-year-old man, ran afoul of this law when he invited 2 African Americans to his apartment in a Houston suburb. One guest got jealous when Lawrence flirted with the other guest. The jealous guest left and called the police, claiming that an African-American guest was waving a gun at a party. The police arrived, and the offended guest pointed to Lawrence's apartment. When the police entered, Lawrence was in bed having sex with the other guest. They were arrested and spent the night in jail. At the time of the trial, Lamba Legal represented Lawrence, and seeing an opportunity to overturn the law, they had him plead no contest to the charge. Thus, Lawrence and his guest were found guilty of engaging in deviant behavior and fined $125. Lawrence, with the help of Lamba Legal, then appealed the fine in criminal court to a 3-judge panel, which overturned the conviction because they believed the law did not extend to the privacy of one's home, and that the Texas law violated the Equal Rights Amendment in the Texas Constitution. However, the en banc full Texas Appeals Court reinstated the conviction on a 7-2 vote, rejecting the due process and equal protection arguments of Lawrence. He then appealed the ruling to the Texas Court of Criminal Appeals, the highest court in the state. That court refused to take the case up, so it became eligible for appeal to the U.S. Supreme Court, which granted certiorari. Amicus briefs on Lawrence's behalf were filed by the American Bar Association, the American Psychological Society, the American Public Health Association, the Log Cabin Republicans, and many more. Even Republican Senator Alan Simpson wrote an op-ed in the Wall Street Journal supporting Lawrence's appeal. The Supreme Court overturned the conviction, with Justice Kennedy again writing the majority opinion in a 6-3 decision. He rejected the view that a state's majority of citizens could limit the natural rights of the minority of citizens in the state. Quote, when homosexual conduct is made criminal by law of the state, that declaration in and of itself is an invitation to subject homosexual persons to discrimination, unquote. In other words, you can't criminalize behavior simply because you find it distasteful, particularly when the discrimination results in penalizing a particular class of people. Kennedy also concluded that citizens had a presumption of liberty that required the state to establish a compelling interest in order to deprive one of such liberty. The law was unconstitutional because it affected, quote, the most private human conduct, sexual behavior in the most private of places, a bedroom in the home, unquote. Kennedy also invoked the Due Process Clause of the 14th Amendment, and in her concurring opinion, Justice Sandra Day O'Connor invoked the Equal Protection Clause. Thus, in 2003, the Supreme Court not only had overturned the Hardwick ruling, it set the stage for full equality for LGBT citizens. More states began to legalize same-sex marriage, including California. Professor Kevin Johnson, the research director for the Center of First Amendment Studies, will now tell you what happened next and discuss the implications for the future. Kevin?
I'd like to thank you all for coming out this evening in celebration of our Constitution Day. The Constitution works in mysterious ways. It is active, contested, messy. We like it when it's convenient to our political ideology, and we negate it or try to get it to say what we want when it's not convenient to our political ideology. This process is the way ideas are contested in democratic deliberation. Sometimes constitutional issues make their way to the Supreme Court with blazing speed, while at other times the path takes much longer. The recent cases involving same-sex marriage took a long path before reaching the Supreme Court and may take even longer before being entirely settled. The purpose of my presentation today is to share with you some of the complexities involved in the constitutional debate over same-sex marriage. I've organized my thoughts today into 2 sections. First, I'll explain how same-sex marriage entered the court system to begin with and share the major rulings in the recent cases. And then second, I'll explain why the core of the constitutional contest over same-sex marriage appears to be about whether homosexuality is something that people are or something that people do. In doing so, I'll explain a First Amendment framing of the constitutional arguments that may be the already given equal protection arguments in the public sphere. But let's begin how we got here in the first place. It's important to note that same-sex marriage has not always occupied a privileged space on the LGBT rights agenda. In 1993 and 1994, the LGBT movement was preoccupied with legislative fights over employment discrimination, housing discrimination, Bill Clinton's Don't Ask, Don't Tell policy, along with moving forward on a whole lot of other different kinds of ordinances. The national movement in the early 1990s seemed focused on other priorities than same-sex marriage. Meanwhile, out in Hawaii, 3 same-sex couples filed for marriage licenses in the state. They had met every legal requirement for the state's recognition of marriage, except for being of the same sex. Hawaii's Department of Health, who issues the licenses, consulted with the state's Attorney General, who asserted that under the Constitution, the right to marry is fundamental, but only for different sex couples. The Department of Health denied the marriage licenses, and the 3 couples filed suit against the state of Hawaii in violation of Hawaii's Constitution. In 1993, Hawaii's Supreme Court required the lower court to demonstrate a compelling state interest for denying same-sex marriage rights. So the legislature reacted to that by forming a commission to study whether there was a compelling interest. Then in 1995, the commission recommended that Hawaii extend open marriage to same-sex couples. What this did was that it sent shockwaves through the Bible Belt of the United States. More conservative states began to fear that they would have to recognize Hawaii's marriage in their own states. As a result, anti-same-sex marriage ordinances began spreading throughout the United States. And as a result of that spread, the LGBT movement was forced to shift its focus away from its national agenda of gaining protections against key items like employment discrimination, of which there is still no federal protection, and toward countering the anti-gay ideology embedded now in the anti-same-sex marriage arguments. So they were drawn into this particular argument. So throughout the 1990s, same-sex marriage went from an issue relatively low on the LGBT movement's agenda to arguably a central place in today's movement. So where are we today? There's 2 important cases that I'm sure that you have all heard about that have been recently decided in the Supreme Court. These involve the Federal Defense of Marriage Act and California's Proposition 8. So first, I'll talk briefly about the case of United States versus Windsor, which had to do with the Federal Defense of Marriage Act. In 2007, 2 women who were residents of New York married each other in a lawful ceremony in Ontario, Canada. Edith Windsor and Thea Spire returned to their home in New York City after their marriage. When Spire died 2 years later in 2009, she left her entire estate to Windsor. As a widow, Windsor sought to claim a state tax exemption for surviving spouses. She was barred from doing so because the federal DOMA law, which excluded a same-sex partner from the definition of spouse, as that term is used in federal statutes. So Windsor, what she did was paid the taxes, but filed suit to challenge the constitutionality of the provision. The case recently reached the Supreme Court, and the court ruled, quote, this is from the majority opinion, DOMA singles out a class of persons deemed by a state entitled to recognition and protection to enhance their own liberty. It imposes a disability on the class by refusing to acknowledge a status the state finds dignified and proper, end quote. So there are 2 important things to note in this ruling. The first of which is that the ruling does not say that same-sex marriage is the constitutional right of same-sex couples. It carefully explains that a state, in this case, the state of New York, has the power to determine what recognitions and protections are necessary to enhance their own liberty absent a compelling federal government interest otherwise. And second, the ruling is confined to those couples that are legally married already. In other words, because the state of New York recognized the marriage of Winslow and Spire, the federal government could not overrule that state recognition at the federal level since there is no interstate conflict involving the federal interest. Thus, the court left open the right of states to determine whether or not they wanted to recognize same-sex marriage, or at least deferred the decision until much later, where we haven't been yet. The second case that we're all much more familiar with maybe is Hollingsworth versus Perry. After the California Supreme Court held that limiting marriage to opposite-sex couples violated the California Constitution, state voters passed a ballot initiative that many of us are familiar with, Proposition 8. The proposition amended the state constitution to define marriage as a union between a man and a woman. What then happened was a somewhat bizarre path to the Supreme Court. Same-sex couples who wanted to marry filed suit in federal court challenging Proposition 8 under the due process and equal protection clauses of the 14th Amendment. And it named as defendants California's governor and other state and local officials responsible for enforcing California's marriage laws. However, in the case, the officials that were named refused to defend the law. So instead of the public officials defending the public law, the district court allowed the proposition's official sponsors, a private party, to intervene and defend it. So when it came to the Supreme Court, the court ruled that it is unconstitutional for a private party to represent the public in federal court. In other words, only public officials are able to defend the public in federal court. And because they did not do so in this case, Proposition 8 would be upheld as unconstitutional because the state did not levy a defense. Okay? Again, in this case, I think there's a couple implications that are drawn from it. The first is that a precedent was set that public officials are able to refuse representing the democratic will of the people. Regardless of your feelings or your feelings about this on this particular political issue, the precedent is set that public officials may veto future constitutional amendments in the state of California because they don't want to defend whatever the amendment is in federal court. So they can just refuse to be defending the constitutional amendment that the people passed. And the second implication is that since Proposition 8 was effectively overruled, it left the previous California Supreme Court ruling intact such that same-sex couples may marry in the state of California. Okay? The second one was much more focused on for obvious reasons. So having discussed the landscape of the constitutional cases, I'd like to turn to an observation about the state of constitutional debate as it currently exists on same-sex marriage. Thus far, our national debate over same-sex marriage has been primarily framed in terms of equal protection clause and due process arguments. These arguments are rooted in the idea that sexual identity is something that comes to define what people are. Those opposed to same-sex marriage and the equal protection argument, however, are inclined to believe that sexual identity is defined by what people do. Thus, those unpersuaded by the Equal Protection Clause argument argue that the Equal Protection Clause is for protection of people as they are and as they were born, not for protecting the sexual behaviors of what people do or choose to engage in. In other words, they remain less convinced of a gay gene, potentially, and more convinced that being gay is a behavior. Thus, from that ideological perspective, the Equal Protection Clause arguments are not all that persuasive to some, okay? I believe that there's a different and potentially a more persuasive path than those Equal Protection Clause arguments that have been advanced thus far. One need not concede the Equal Protection Clause argument in order to imagine this different path of constitutional argumentation. Specifically, I would identify two paths that remain untraveled and under-researched when it comes to constitutional law. Specifically, I think it's possible to frame same-sex marriage as a fundamental right concerning the freedom of expression. which is the Center for First Amendment Studies issue. There are at least two ways to make such an argument at the outset. The first of which is that one could argue that it is viewpoint discrimination and a violation of the freedom of expression guaranteed by the First Amendment. In other words, no attorney has ever opened their oral arguments in a court of law with a quote that would go something like this. I'm not a constitutional attorney, but it might sound something like this. Mr. Chief Justice, and may it please the court, when a woman stands in front of a justice of the peace, she may express her love and lifelong vows for another person only if that person is a member of the opposite sex. She cannot express her love and lifelong vows for a woman of the same sex, and that is viewpoint discrimination in violation of the First Amendment of the United States Constitution. Opening up an oral argument, something like that. So this is based on a reciprocal expressive institution to which you would then have to demonstrate a compelling government interest to be able to restrict the expressive right. The second reason that I think that the First Amendment is implicated here, and it's potentially even more important, is that marriage is a symbolic institution. It is a public declaration. It is not a private ceremony. In fact, the entire national controversy is over the meaning of that symbol and what it ought to mean. The fact that it is a symbolic contest may be evidence of it being a type of symbolic expression. Denial of a marriage license is fundamentally a denial of the symbolic expression that comes with the marriage license. Marriage is a political act, and political expression is at the heart of First Amendment protection. So now, I'm not sure that these arguments would resolve the debate, but at least I think it would garner a little bit more complexity when we're talking about the constitutional arguments that are at a stalemate when it comes to equal protection and due process kinds of arguments. Although that debate is unlikely to end anytime soon. The purpose of my Constitution Day talk was to share with you some of the complexities involved in the constitutional debate over same-sex marriage. I did this by highlighting some of the constitutional issues, as well as the issues involved in the recent Supreme Court decisions, and by offering some more complexity regarding the possible First Amendment questions on the subject. Freedom of expression is at the core of our democratic society and enables lively debate on this issue. Out of the marketplace of ideas, hopefully we are equipped to agree that the marketplace is one where all ideas may be offered, even while some are perhaps less deserving of being purchased. Information and the expression of ideas is the currency of democracy. And while I might not be the biggest fan of market metaphors, I am a fan of the freedom of expression as a fundamental right in a rich and vibrant democracy. And so, as we continue our contest over same-sex marriage in the United States, may we also pause a little bit on our Constitution Day to remember the Constitution's role in getting us into this messy debate, and to remember that democracy is messy, but in my view, very much worth the mess. Thank you for coming today.
Before we get to some questions from you all, just a few things. First of all, I'd like to introduce one of our big supporters. The Dean of the College of Liberal Arts, David Wallace, is here, and we appreciate all of your efforts on our behalf. You can also go online to the Center for First Amendment Studies. It's at www.firstamendmentstudies.org. Very easy. And there are lots of research papers on various First Amendment issues that you can use in class and cite and so on and so forth. Don't plagiarize them, just cite them. And there are a couple of ebooks on the First Amendment and religion and the First Amendment and the media. So I invite you to go to that website. We've done a lot of different things at the Center for First Amendment Studies that have included forums in the city of Rome in Italy on these issues. We've taken students over to Rome, where we have an affiliation with John Cabot University, an American university there, where Kevin and I have taught for several years. And we have also been able to establish contact with some members of the Supreme Court. Justice Alito came to John Cabot University, and we were able to have dinner with him in a private conversation to get his take on certain things. And Kevin has visited the Supreme Court and the chambers of Justice Kennedy. So we have been talking to these people, and we think we know where they are coming from. We've also written a book with a chapter on each of the justices on the Supreme Court. Okay, one last thing. Kevin brings up a very interesting interpretation of the First Amendment in applying it to same-sex marriage, that same-sex marriage would be expression and therefore protected under the First Amendment. It could be symbolic speech, which would be protected under the First Amendment. And you all should know a little bit about what the Supreme Court has said about symbolic speech, because one of the first and most important cases involved students demonstrating symbolically on a high school campus. A family, the Tinker family, their children protested the war in Vietnam by wearing black armbands to school. Symbolic speech. They were expelled. Some said for their own safety, some said because they were disruptive. In any case, they were expelled. They appealed all the way to the Supreme Court and said that the armbands were symbolic speech and were protected. And the Supreme Court ruled in their favor. It said you do not lose your First Amendment rights at the schoolhouse door. So you should all know that. Now, while the Supreme Court has cut back a little bit, particularly in high school situations, they haven't at the college level. And so you do have the right, freedom of expression in public forums, not in the classroom. That's a learning environment, and that's a whole different, you got academic freedom there, but you don't have freedom of expression there, okay? So I think it's important for you to know that. Questions from you that we can answer? We were that thorough? Any questions at all? Yes, sir.
I was just curious because during Dr. Johnson's speech, he talked a lot about the First Amendment and how it applies to that symbolic expression. I was just curious because there's a lot of new academic research coming out about sexuality and how it's more fluid in terms of its performativity, and wondering if there's anything sort of, I guess, coming about with regards to new, like, freedoms of expression with that regard?
The question concerns the fluidity of sexuality, and this goes back to some of the original research that was done that had people on a scale from extremely homosexual to extremely heterosexual, and most of us are a little more toward the middle, and whether that fluidity is involved with symbolic speech and expression. Do you want to talk to that, since you raised the point?
Sure. When we're talking about the issue of marriage, it's a little bit different than the sexuality or the behaviors that are regulated as per Dr. Smith's talk. So when he was talking about the cases of Lawrence versus Texas, it's about the regulation of the Sex Act. And I think that that's what you would be more speaking toward. The issue of marriage as a symbolic institution is defined in very different ways. The fundamental characteristic of marriage, depending on who you ask, is not necessarily the sexual relation. And it hasn't been that way historically in terms of the way that we come to think about marriage in the context of the constitutionality debate. So if we're thinking about marriage per se, I think that marriage, if it's in the Supreme Court context, can be a type of symbolic speech. You just sparked a thought in my mind, though, is that fluidity is not necessarily new in terms of its research. It's been there for many, many years. And the fluidity of sexuality is one of the reasons why same-sex marriage wasn't at the forefront of the LGBT agenda in the early 1990s to begin with, is because it was a divided issue. Paula Edelbrecht wrote an article that said, "Since when is marriage a path to liberation?" It's not exactly working for women women all that well. So what's to say that it's going to work for same-sex couples all that well, right? And so there's this undermining sense of why is marriage going to be the focus of our LGBT rights? Why not focus on things that are not necessarily about our relationships, but the way that we're treated in the workforce or the way that we're denied housing? And so those are places where I think that the movement really started to stick because they were divided over, I think, this question of fluidity. But in the marriage institution, I think it's a very different history than maybe some of the Lawrence versus Texas and Bauer versus Hardwick, these other decisions. And they're related in popular discourse, but in legal field, it's you really have to do the work to draw those connections, I think.
And I think the other thing that's relevant to that is there are people who feel, and as I said, I'm hoping we're here to enlighten, there are people who feel that we should change the whole system to one of civil unions, and then you just go bless it in your church. But everybody would have a civil union, and then you would get your rights, your benefits, your Social Security, all of that stuff through the civil union, and you wouldn't be mixing the religious side of things with the civil side of things. Remember, we're supposed to have a separation of church and state, and when it comes to marriage, we don't. This is maybe one of the fundamental ways we could work our way out of that. Any other questions? Yes?
States that are issuing same-sex marriage licenses, how are other states responding to those? Same-sex couple relocates?
The question is, what if you get married in one state and move to another, does the other state recognize it? Most states have reciprocal agreements. So if the marriage is upheld, that state has to recognize that marriage. But there are legislatures in certain regions of the country, as you might imagine, that are rewriting their laws and saying they're not going to recognize marriages that are same-sex marriage. They're trying to legislate that. I think that'll result in another round of cases that'll go to the Supreme Court. That'll be struck down, and they'll have to recognize what goes on in other states.
Will that be litigated on full faith and credit grounds?
Yeah.
I'll also say that I don't think, in my reading of the opinion, that the part of DOMA that said that one state had to recognize another state, I don't think that part of DOMA was overturned. And so it did set a federal mandate that said that if one state recognizes the same-sex marriage, it means that another state doesn't have to if they don't want to. Now, whether or not there's that reciprocal agreement and they challenge that in courts and then that becomes an issue, I think is entirely separate. But I think that DOMA provision is still in effect that doesn't require one state to recognize the marriage in another state.
And thank you for the question, because it reminds me that in certain states where same-sex marriage is supposedly not allowed, certain county clerks are performing same-sex marriage ceremonies. This is happening in New Mexico, and so all these people from different parts of New Mexico are running to this one county clerk to get married, because the county clerk is arguing that the Supreme Court decision said that we really can't prohibit same-sex marriage. That clerk is counting it as a kind of precedent. So you have people, in counties in different states redefining what a marriage is inside the state based on the Supreme Court ruling. So it's really getting complicated. And that's a good thing, because that'll all obviously bubble up to the Supreme Court, and they're going to have to work it out one way or the other. Time for one more question. Yes, sir.
So when it comes to marriage or different kinds of civil unions, like, people end up getting different kinds of protections when they have this new status. If there is a decision that allows for, like, the legal acknowledgement of this as being like a federally legitimate relationship, how will this affect other forms of like discrimination or other forms of like protections among classifications of people?
The question concerns the extension of protections among various classes of people if you give this protection to same-sex marriages. I think the first thing, my first response would be allowing same-sex marriages brings those people up to the level that other people have. If you go back to the case I examined, Loving versus Virginia, which allowed a black person to marry a white person, it merely brings same-sex people up to the Loving standard. And so it gets them there. The other thing that people have been talking about is the whole issue of benefits, and if you allow same-sex marriages and then same-sex benefits that are allowed in other cases. It's going to be expensive because insurance is going to be extended, Social Security rights are going to be extended, and so on and so forth. But we have never said because it's expensive, it's not going to be allowed. If it's constitutional, and people are going to have to deal with it. So today we've celebrated the Constitution, and it's over 250 years of age, and it's only been amended 27 times. And the most recent amendment was in the 1990s, and that amendment was written by James Madison. It was going to be the first amendment to the Constitution, and it said Congress can't give itself a raise, it can only give future Congresses a raise. The Congress passed it, but the states never ratified it, but it had no time limit. So a student at the University of Texas decided he wanted to get this amendment passed in the name of James Madison. And he lobbied and he argued, and finally it was ratified and became the 27th Amendment to the Constitution. So James Madison wrote the first amendment to the Constitution and wrote the last amendment to the Constitution, thanks to this student from Texas. Hope you all have a nice day. Thank you all for coming.